So greetings, everyone. My name is Peter Young, and I am on the board of Societe de Chimie Industrielle and also head of programs. And I want to welcome all of you to what I think is a very important webcast and panel on a topic that no matter what part of life sciences or chemicals you're in, it's a critical part. These are critical parts of the system that allow innovations to happen and people to invent things and be motivated to spend the money to develop products. So I'm also particularly pleased with the panel that we have here assembled. I won't read all their bios because that is on the invitation, but in no particular order, we have three distinguished and very experienced people. Andrei Inagu, who is a partner at Irell and Manella, and he has been in the whole intellectual property area for a long career, but he was also most recently the director of the U.S. Patent and Trademark Office. And actually, we featured him in a webcast about, I guess, about a year and a half ago, right, Andrei? And from his home as he was managing the patent office. We also have Paul Llewellyn, who is a partner at Arnold and Porter. He has a long career dealing with a variety of industries, including life sciences, et cetera. His area of specialty is in particular on brands and trademarks, which we know are an important part of the system as well. And Charles Miller, I've known for many years. He's a senior counsel of Leichtman Law, and he is in patent, trademark, and copyright, and was previously a board member of Societe de Chimie Industrielle, and is now in private practice. So with that, let me get started. So first of all, what I'd like to do is ask each of you to just take 2 minutes to tell the audience about your background and what you do on the intellectual property and trademark side. So no particular order. Paul, do you want to get started?
Sure. Thank you, Peter. Thanks for that introduction. And thanks for including me on this esteemed panel. As Peter said, my focus is primarily in the trademark and brand protection area. And of course, that includes not just things like your house mark or product name, but non-traditional marks, such as trade dress, colors, even product configuration, which are often important in this area. My work includes both litigation and counseling, a fair amount of trademark registration work, managing global trademark portfolios, and similar activities. And my clients are in a variety of industries, including a lot in life sciences, some chemical manufacturers, biochemical manufacturers, some consumer products companies, and so forth.
That's right. And for full disclosure, Paul and his firm, I'm a client of theirs, so I can vouch for the quality of their work. Andrei, would you like to go next?
Sure. Thanks, Paul. Thanks, Peter, for the kind intro. Great to be with you, Paul and Charles, and with the whole Societe. And I very much look forward to another great discussion like we had about, as you said, a year and a half ago or so, which was a lot of fun back then, and I'm sure it's going to be again today. As Peter mentioned, I was the director of the US PTO for a few years, but before then I was in private practice at Irell and Manella. I am now back at Irell and Manella. And over the past 25 years, minus the 3 years in government, I've been focused almost exclusively on intellectual property, mostly litigation and counseling. And that's what I'm doing now, and in a variety of industries, including life sciences, but it really spans the gamut of industries, both on the patent owner side as well as on the accused infringer side. And as I said, mostly patents, but really all aspects of IP. Now, after government, in addition to my normal practice, which is, as I said, mostly litigation and the like, I also advise clients on policy-related matters, IP policy related matters, such as pending or potential legislation, general trends in industry, and the like. So,
By the way, I'll mention that, Andrei, I have to tell you, you made patents and intellectual property an actually exciting discussion when you had your webcast. And I tell you, although I thought I knew something about patents, learning some of the things about the history was fascinating, including, as I recall, you're telling us that George Washington signed the first the patent. Is my memory correct?
Your memory is correct. And actually, Peter, let's see if you remember this. What was that first patent that George Washington signed? And two-part question, and when was it?
It was a chemical one.
Yeah, there you go.
And I don't remember what it was. It might have been something like potash or something.
Exactly.
And the head of the patent office was Thomas Jefferson.
Yeah, and it was in 1790, immediately, really, within a few months of the forming of the new government. But yeah, it was potash, it was chemical, so very pertinent to this.
So that proves, Andrei, that I'm not a candidate for an Alzheimer's drug just yet. Charles?
Yes, thank you, Peter, for hosting this webinar. And I'm delighted and actually honored to be on the panel with Paul and Andrei. I'm an old timer in a sense because I go back to the early 1960s when I was in graduate school in chemistry at Columbia. And I developed during the course of my work there in organic chemistry and an interest in patent law. And I continued my interest beyond my doctorate at Columbia. And I went to NYU Law School beginning in the mid 1960s. And after I was graduated from there, I was very fortunate to land a position at what was then known as Allied Chemical in New York City that was looking for a patent trainee, which is what I was looking for at the time. Allied Chemical, as you may know, eventually evolved into what is today Honeywell International. My work has been over the years mainly in the chemical arts and in the pharmaceutical areas as a reflection of my background in chemistry at Columbia. My work has, particularly after leaving Allied Chemical and later Celanese, where I was there for 2 years, I worked at a law firm called Penny & Edmonds for about 31 years, during which I segued into litigation, counseling, licensing, and as well as patent prosecution, which is what I learned while I was at Allied Chemical and at Celanese. And today, my area is of particular interest is in the litigation and particularly the appellate area of patent cases and trademark cases.
Yeah, wonderful. Well, I'd like to start out. This is a fireside chat, no slides and so forth. And what I'm going to do is I'm going to go through a couple of questions, and then each of the panelists really can choose to either comment or not comment on a question depending upon their interest in information. I think the first one is, what are the most significant changes in legislation and court actions, both of which are important factors, that have occurred in recent years in terms of patent laws and intellectual property? If you thought this area was boring, you're totally wrong, because there are constantly changes in many aspects, such as legislation and practice and regulation. So for our audience, which are executives and people in the chemical and life science industries, what are the most significant changes that in recent years that you would like to point out that you think is important for the audience to focus on? And this is open to anyone who wishes to comment.
Well, I could start, Peter, if you'd like, or Charles.
Yes, please, go ahead.
Charles smiling, nodding his head, so maybe you can go first.
Yeah, go ahead, Andrei.
Okay.
Yeah, okay, happy to do it. Well, look, actually, I think for this particular industry, one of the most interesting developments is what has not happened. Because one of the most important areas of law that remains in flux is Section 101 of the Patent Code, patentable subject matter. And it's particularly important in the life sciences industry, where a lot of the patents and innovations deal with what folks term as natural phenomena or products of nature, and processing those. And as you know, that the courts over the past few decades have added exceptions and interpreted those exceptions to Section 101. And the area has been in quite a bit of flux, including the inability basically to patent usually diagnostic techniques and diagnostic innovations. And so folks were hoping that that would change. There's been significant legislative push in this regard. There were hearings, long hearings on Section 101 issues, multiple days in the summer of 2019, if I'm not mistaken. And folks were hoping that something could happen in Congress. Lo and behold, nothing has yet happened. There's no bill, no proposed bill. Having said that, some folks are still working on it. Something could still happen in this Congress, although it's, time is running out and we have an election coming up. But there is increased hope that something could happen in the next Congress, and maybe early, and maybe as early as the first part of next calendar year. Then on the court side on this issue, a lot of folks in industry put hope in the American Axle case, which was a petition for cert was filed with the Supreme Court. The Supreme Court was interested enough to seek the views of the administration. The administration took at least or about a year to respond. It did respond earlier this year, and the administration strongly urged the Supreme Court to take the case. A lot of other folks in industry had the same recommendations for the court, and yet just a couple of weeks ago, the court declined to take the case up for review. So after all these years, there is still no indication from the Supreme Court that they're interested in addressing Section 101. The biggest changes, frankly, have been on the administration side at the Patent Office itself, where in 2019, we did put forward Section 101 guidelines. The new director, Director Kathy Vidal, who is in the seat now, has indicated publicly that the office is continuing to look at the issue, and if there's more that the office can do, so there might be further attention to this issue from the administration side. At least there has been and there might be some movement on the administration side. There has been, I'll mention one more thing and then turn it to the others. I'll mention one more quick thing. So there has been court action on Section 112 that's pertinent to this group. Generally, the Federal Circuit has tightened up what qualifies as appropriate disclosure under Section 112 for what it calls the unpredictable arts, such as chemical arts, life sciences, biological technologies, and so on. And those decisions are now again on cert petition to the Supreme Court. There's the Amgen case that has been filed recently at the Supreme Court, and then most recently the Juno case, Juno v. Kite. Also, cert petition has been filed just, I want to say, a week or two ago. I can't talk much about that because, in full disclosure, I am involved in that particular case. But those petitions are pending now at the Supreme Court, and we'll see if there's some action on that front. So let me just stop there.
Yeah, good. Wonderful.
Charlie? I'd like to add some. I don't have much to add beyond what Andrei has said in terms of what he did, but I would note that in my own practice with respect to Section 101, which is it's a surprisingly short section of the Patent Act. And it simply says that whoever invents or discovers any new and useful machine, article of manufacture, process, or composition of matter or improvement thereof may obtain a patent subject to the conditions and requirements of the Patent Act, period. It's about 36 words. And yet it bedeviled so many people, including myself, in trying to figure out how can one reconcile this statute, which has been around for decades, with what's been going on in the courts in the area of patent ineligibility. Every single case that I've been involved in over the past several years, an issue has been raised by the defendant against whom the patent is being asserted that, well, claim such and such, or these claims are not valid because they are ineligible for patenting. And then it goes into a motion before the judge. And it seems that so many cases, particularly in the software cases, computers, software, and not only that, but in diagnostics, patent claims fall. They fail and are held invalid on that basis. And the Supreme Court has, about 10 or 12 years ago, enunciated a rule for assessing patent eligibility in two cases, one involving a diagnostic method, it called a Mayo Clinic versus Prometheus, which I was dumbfounded when I read the decision. I couldn't understand how such a useful invention and in monitoring the efficacy of certain medications applied to a patient could be held to be not patentable subject matter in terms of its eligibility. But that, and then coupled with the subsequent case called Alice, about a year or two later, together was put together by the Supreme Court in a test that has been applied ever since. And it's been criticized far more often than supported. And I think that what bottom line from my perspective is clients come to me and say, why should I assert my patent against such and such a company if my chances, based upon what I've been hearing and reading about, are nil or virtually nil in getting the claims that I want to assert upheld on grounds of eligibility? The cases that I'm involved in, you can always expect a motion from the defendant for dismissal of the action because the claims being asserted are ineligible and they have to be responded to. And what does the court have to work with? It has to work with what the Supreme Court said in the Mayo and Alice cases. So where do we go from here? I think that based on the fact that certiorari in the American Axle case was denied a few weeks ago, as Andrei mentioned, I think we have the only recourse right now is to look to Congress. And the Patent Office has an excellent set of guidelines for its examiners, but those guidelines are not binding on the courts. So what we need is something binding on everybody, and that would be through Congress. So I think the ball is in Congress's court, and the American Bar Association has put forth, together with the Intellectual Property Owners Association, a set of proposed changes to Section 101 in order to try to make it less useful to those who want to simply avoid having to get into the weeds on the validity of a patent based on obviousness, anticipation, utility, and so on, and try to get out of the case quickly by a quick and dirty ineligibility motion. And I think that situation needs to change. Otherwise, we're going to see a lot of doubt, more doubt than has already been raised on the part of applicants, patent owners, with respect to the viability of the U.S. patent system.
Well, sadly, trying to get things through Congress is not easy, no matter what the topic is these days, right? You know, Paul, I know that this question was focused on intellectual property and patents, but maybe you might want to comment on whether there are any new developments in the court system or the rules as they affect trademarks and brands, which obviously are just as important for most of the people on this, watching this webcast. Any new developments that you can think of that are worth mentioning?
Oh, sure. It's a little technical, but it's certainly relevant, I think. Less than a year ago, legislation called the Trademark Modernization Act went into effect, which is a little bit technical, like I said, but it relates to the ability to challenge trademark registrations that aren't really in use for all the goods that are listed in the registration. And basically, it's made it a lot easier for a competitor, for example, even anonymously, to rat you out to the trademark office and say, we don't think they're really using their registration for all these goods, or they never did. And then the burden falls to the registrant to show that you really are. And the reason this is relevant is that the US has always been a use it or lose it country for trademark registrations. But it's never been as easy as it is now to challenge somebody else's registration for non-use. And a lot of companies have a tendency to secure a registration, and they maybe have it all in use for all the goods in their registration, and then they kind of forget about it and they don't really pay a lot of attention to it. But your trademark portfolio is sort of like a garden that you have to go out and weed every once in a while, and you have to tend to and make sure everything is in use. Otherwise, you face a real risk of just losing the rights that you spent a lot of money and effort to get in the first place.
So Paul, it's sort of like the sports phrase, use it or lose it, right?
That's exactly right.
Yeah. Now, the next question is
Peter,
maybe...
before
Yeah, go ahead.
we go to the next question, if you don't mind, let me add a couple of very quick comments.
Sure.
First of all, to Paul's point, I didn't mention it knowing that Paul is going to come up next with the trademark side of things. But the Trademark Modernization Act is super important. It is of all the IP pieces of legislation in the past, let's say 5 years or so, this is the most important. And it is, in addition to that, it is the most significant piece of trademark legislation in the past 50 years or so. It has a whole host of provisions that were put into place. Some of them are technical, as Paul mentioned. Others are fairly high level. I'll give you an example. One of the items in the TMA, the Trademark Modernization Act, is a legislative overruling of the eBay case for trademark cases. In other words, make it clear that irreparable harm is to be presumed, and therefore an injunction should issue if there is a finding of trademark infringement. So that's a significant piece of legislation. In addition to giving the PTO extra tools to fight fraudulent trademarks and fraudulent registrations from nefarious actors, which has become a scourge on our economy. So with the additional tools, hopefully the PTO can make, the trademark office can make further inroads on that. So it's an important piece of legislation. It was the last major thing that we did before I left office on the IP front, and quite proud of it. Folks, the trademark bar is already making significant use of the various provisions.
So this is one of the few pieces of legislation that's labeled modernization that actually earn the right to use that phrase right in there in the title, right? I have another question, which actually maybe Andrei, you could take the lead in answering. Is laws are laws and legislation, et cetera. But the practices of the patent and trademark, office are a really important part of the equation, right? When you're a company trying to deal with these issues. So have you seen over not only during your tenure, but before that, what kind of changes in the patent office's practice have occurred that have some impact on the life science and chemical industries?
Yeah, look, there are a lot of changes at the PTO. The PTO is a very nimble organization. I know that it's a government agency, but nevertheless, it in many ways behaves as a private enterprise that is quick on its feet, very attentive to the needs of the user base, and responsive to those needs. It really is a remarkable agency that's driven in large part by self-funding. In other words, all of its revenue comes from user fees. The PTO does not depend on taxpayer dollars, so it runs, as I said, more like a private nonprofit, of course, enterprise, and is quick to make changes if those are needed. So relevant to your question, Peter, Section 101 is a very good example. When we see the confusion that's in the court decisions. Congress has not legislated here in a very long time on Section 101. The PTO responded and continues to respond. By the way, Section 101, the actual statute, has not changed since 1793. And I'm not kidding. It was written word for word as we have it now by Jefferson and Madison in 1793, and hasn't been changed since by Congress. And that, by the way, is part of the issue we have with Section 101. Because as brilliant as those guys were, and there's no question that they were absolutely brilliant, they still did not predict DNA processing and various chemical formulations and software code and artificial intelligence and cryptography and on and on. And the courts, are struggling on some of these things to figure out. You have an 18th century statute, but with 21st century technology, where are the lines? What fits, what doesn't fit? And that's why, as both Charles and I have said, really the only entity that can solve this is Congress, and it needs to address it again for the first time since 1793. But the office has. So the office did the best we could in 2019, and we issued guidelines that were very successful. Those guidelines improved the accuracy of 101 examination by 44% in the first year after issuance. But as Charles said, we cannot change law at the PTO, and courts are not bound what the PTO does. So, it's only good for examination. So the confusion in the court system remains. That's why Congress needs to step in. But again, the PTO has responded. There is more change afoot at the PTO in these areas. So as I already mentioned, the director said that they keep looking at Section 101, but they're also looking at continuation practice, at terminal disclaimer practice, double patenting issues, a host of other things that we can get into later in the program.
Well, it's very interesting, and actually, Andrei, you sort of touched on one of my favorite topics, which is the founding fathers did a wonderful job in terms of the Constitution, the three branches of government, et cetera. And some of those have held up well over time, and others, like for example, Congress versus the Supreme Court versus president, when you devise a system that was designed to run 13 states and a couple million people, it doesn't quite function as well, a couple hundred years later when things have to be decided earlier. And that's one reason why the president has more power today than 200, 300 years ago. But similarly, like in areas like patents, some things have held up well, and I guess you're saying some have kind of gotten stalled just because the system hasn't made adjustments. So that's an interesting, topic. You actually started into the next question, which is really, what do you see as what do all of you see as changes that you expect in the future, both in terms of the PTO's policies and actions, but also legislation and court actions? I think you all started to talk a little bit about that. Anything that, Charles, for example, that you would mention, that putting your crystal ball, in front of you and thinking the future?
Yeah, I think that the problem of artificial intelligence as a potential patent, an inventor or a patentee under Section 101, if one were to interpret the word whoever invents or discovers any new and useful invention, any new and useful, etc., the word whoever is going to be subject to interpretation either by the Supreme Court someday, or by additional definition by congressional legislation. I can see in my own mind's eye that years from now, artificial intelligence will mean machines that are smarter than we are. And then you have to decide, well, can a computer make an invention independently of its human masters? Probably not now, but I think someday it'll happen, and Section 101, and as well as many other aspects of patent law, will have to change, because when you talk about an individual person as an inventor, certain legal implications arise from that across the board. And when that inventor can also be a computer, then you have to look at the whole law of individual relationships between contracts and litigation and parties, et cetera, et cetera. So it's an exciting area, I think.
So Charlie, has your laptop invented anything that's patentable recently?
Well, I was working on my laptop and it fell off the desk and it fell onto my foot. And I said, well, that laptop is not an abstract idea because it really hurt.
Paul, anything, your crystal ball on the trademark, on the trademark and branding side?
As far as the PTO goes, I don't know about that. I think that as Andrei said, there's certainly buckling down on fraudulent registrations, which is causing a lot of I think higher scrutiny of everybody's applications, which is challenging. One change I would say that I would like to see, and not to disagree with what was said before about how great the agency is this a challenge we've been facing is the time lag in the examination of applications, which I think has a very practical effect on clients. I have clients who ask us to clear marks, and they ask us to clear marks because they don't want to get sued and they want to know that they can get a registration. They don't want to get sued because they don't want that automatic injunction that Andrei talked about, because there's a presumption of irreparable harm. They don't want to have to pay damages or profits. And sometimes when something's on the borderline, the client's like, well, let's apply and see. And then I say, well, these days it's taking 7 months for anyone at the trademark office to even look at your application. So yeah, we'll apply and we'll wait 7 months. But in the modern economy where things move very quickly and where people have an idea and they want to get out there and use it, that's just not practical. So one hope that I have is that on the trademark side of the office, that they will speed that up and get back to at least the 2 months or so that it used to be.
Yeah, well, that's certainly an issue, and it's certainly even the issue when it comes to the FDA and regulatory things. That's the constant tension in terms of, you know, how long it takes. I mean, you know, and many people, as you know, Paul, they just decide not to file for patent and just try to keep it as a trade, you know, as a secret, right, in practice, and just because they don't want to wait that long to get a patent or disclose what they've, you know, invented. So the next question is, I want each of you to say, well, hypothetically, you're in an elevator with the CEO and the general counsel of a company, and you get in on the lobby, and everybody's getting off of the 5th floor, and the CEO turns to you and says, tell me, what are the 1 or 2 things you think are most important that I, as a CEO of a life science company or a, you know, chemical company, have got to worry about, you know, going forward as it relates to the patent area? What would your literally elevator speech, what would it be?
Well, I would say to that hypothetical executive that, to my mind, thing that he should really concern himself with most, among other things, is the patent eligibility issue. If it's got to be resolved someday, because the way it is now, executives such as the kind you meet on elevators, when they learn about this issue, they say, well, why should I bother patenting anything if the patent is not going to be that enforceable with reliability?
Yeah,
Andrei, any comments?
Well, first of all, I agree with that. But what I would say to the executive at a higher level is that you have to worry about the entire state of the patent system when it comes to life sciences in general. The system is under significant political pressure right now, and it's been like that for some time, but now has been exacerbated by the COVID-19 pandemic and access to vaccines and other life-saving technologies. As you probably know, there was a waiver that was put in place at the WTO just last month, and that waiver is currently limited to patent protection for vaccines only, COVID-19 vaccines only, but under discussion right now. There's already significant talk about broadening it to therapeutics and other technologies related to COVID-19. And, if that happens, there is a question as to why not broaden it even further to other very serious illnesses like cancer that kills even more people than COVID, and other and medicines for other diseases. So life science executives have to be very concerned about the overall state of the patent system. One only has to look at the letter the PTO director just recently sent to the commissioner of the FDA. It's a letter dated, I believe, July 6th, with, 5 or 6 pages of recommendations that the PTO itself is going to look at in order to address drug pricing and potential changes coming down the line with respect to, as I said, continuation practice, maybe limiting continuations in this area of technology, potentially dealing with double patenting issues and the use of terminal disclaimers in this area of technology, and lots of other possible recommendations. It's an area that is in very high flux, and of all the technologies, this is the one to watch right now. And by right now, I mean today, this week, next month, this year for sure, that there could be activity affecting the patent system when it comes to therapeutics.
Yeah. In fact, if you look at a big picture, it's a real serious problem, because we really have a big problem on an international basis. I mean, put it very bluntly, what you have here is relatively very high prices. The FDA essentially is, has some of the toughest standards, and versus regulations abroad. But then what happens is it's very costly to get a drug approved. And right now, the high prices are heavily in the US. And then the drug companies end up having to discount heavily in other countries. And so essentially the US consumer is subsidizing drugs. And at some point you say, well, is this fair, right? Is it, because at some point drug company will say, if you're going to crash prices in the US, then how am I going to fund research, right? And then there's a fairness issue. So all this stuff has to be worked out, and it's got a big international aspect to it, because it's very simple. You can get most drugs at a much lower price outside of this country than in this country, right?
Yeah.
And the question is that sustainable long term, right? And
if
the patent thing makes it even worse, right? Because you say, not only do I have to sell it at a lower price in India, but now I lose my patent protection, then it creates a really serious problem.
Call the camel's nose under the tent problem.
Yeah.
It's just the beginning.
Yeah.
I totally agree. There are very serious issues. The international aspect of this is critically important, and we see that in the waiver discussions. That is an international agreement with all members of the WTO agreeing, 170 or so countries. And that's come about because of the international pressure and the US needing to play on a global scale. I want to emphasize, though, that, whatever one thinks about drug pricing and the problems it causes and so on, both domestically and internationally. A lot of the blame right now in the public rhetoric is being placed on the patent system, whereas folks, in my view, need to look at many other contributors
Right.
to these problems. Patents, if anything, increase the ability of companies to invest initially in these life-saving technologies, to bring more of them to market, to create more and more competition by additional new products on the market, and give us the technologies in the first place. I don't think that there is significant evidence that patents act as a barrier to competition in this space, and that patents are the one element that is the significant moving force behind higher prices in the United States. So when there is a public debate about drug pricing, as there should be, it would be great if the public officials would give equal attention to all sorts of other issues in our economy beyond just the patent system.
Yeah, I think that's right. You know, you raised the issue of international, and so I want to raise this question for all of you is, in so many areas, there's an issue about different practices around the world. You know, my wife was involved with the Commission for the Justice Department on rationalizing the antitrust rules around the world because everyone had different rules with regard to, you know, what was a monopoly or not a monopoly, you know, in reporting. On the patent side, I suspect it's very similar, right? In other words, the practices around the world are not all the same. And so that is, you know, a challenge. And certainly one big change that occurred, but it's not recent, but it happened a while, was the you know, the first to file versus first to invent. And that changed to be more, you know, consistent in the US versus the international. Can you comment on this issue of the international? You know, to what extent is there any, you know, convergence or rationalization of international patent regulation around the world?
All right, happy to start on that one as well, Peter. It really depends on the area that we're talking about. As a general principle, it is very difficult to have convergence on specific issues, such as there's still being debated the grace period for prior art considerations, you know, 1 year, 6 months, no months, whatever. And you would think that that's something that folks could harmonize around. Having said that, there has been convergence on this narrow scope of the waiver for COVID-19 as an example. It took a year and a half, and many countries wanted a much broader waiver. Some countries wanted no waiver, and they managed to agree on this very narrow sliver. And we'll see if there is more that comes. What I would say, though, Peter, is for executives out there or patent practitioners in this space, is that it's really important to keep an eye on the changing laws in the various countries. You know, as the climate in the United States might get worse for patents due to a variety of reasons, as we discussed, or it might fluctuate in any event, other jurisdictions might become better for patents, or they might fluctuate as well. Give you an example recently in a different space, but recently there was a case between Ericsson and Apple. There are many cases around the world between the two companies right now. Ericsson obtained an injunction against Apple on standard essential patents in Colombia, of all places. So it's really important. So now, you know, various Apple phones have to be taken off the market in Colombia as a result of that. Practitioners need to keep an open mind and stay abreast various jurisdictions that we didn't think about before that might be coming up as potential hotspots for IP. others that are weakening. It's a continuously global, continuously changing landscape. But IP is the main point here, is that IP is a much more global enterprise right now, and a lot of new areas are developing as powerhouses in the space.
Yeah. By the way, before we continue on, I want to emphasize to those who are in the audience who would like to ask a question, the mechanism is to either type your question in the Q&A box or the chat box, and all of us, the panelists and I, will be able to see the question. I don't see any yet, but please, I'm sure if those of you have any questions, don't use the raise hand because we're not using that function. Just type in your question. Charles and Paul, do you have any comments about the international dimension of either patents and trademarks and what you think the audience needs to understand about that issue?
I would like to emphasize, or maybe expand upon what Andrei has said in terms of the necessity of being aware of what's going on in other countries, even though you may be focusing on the United States for your business, is that there's a practice of lobbying in legislative lobbying and judicial lobbying that's available to companies throughout most countries in the world, with some exceptions. I don't think you can lobby very effectively in China, but in Europe you could certainly lobby courts in terms of being an amicus curiae, file a brief as a friend of the court in support of one position or the other that may affect your own interests. It's a tradition that goes back 200 years in the United States, and in fact, it started back in ancient Rome. And when things happen in countries, particularly in the litigation area, that courts are going to make decisions that could affect you, you should look into the possibility of being able to, put your 2 cents in, rather than simply be a bystander.
Yeah. Paul, any comments on the international horizon, particularly for trademarks and brands?
Sure. It's important to know on the trademark side of things that trademarks are territorial by nature. So when you have rights in the United States, it doesn't mean you have rights in Canada or in the UK or the EU or China, and vice versa. I mean, there's a footnote to that, which is that there's a brewing split among some circuit appellate courts in the United States over whether you can rely on your non-US trademark rights to prevent somebody in the US from using your trademark. But without getting into that detail right now, what I would say, in going back to your earlier question, if I captured the hypothetical CEO in an elevator and gave some advice, I would tell them not only to look at all of your trademark assets, including product configurations and so forth, to make sure you're protecting what you need to protect, both by applying for it and by protecting it in your agreements, like collaboration and supply agreements, but also to not forget outside the US. And there's a tendency of companies, especially when they're in startup mode, to secure their core trademarks in the US, and we'll worry about these other countries when we're expanding outside the US. But there's a pretty efficient international regime that you can use to inexpensively apply for trademark protection for your key marks in at least key markets outside the US early on, that a lot of people don't take advantage, a lot of companies don't take advantage of. And then when they are expanding a few years later, they find somebody else is already there that's using the same or similar market, and it might cost them a lot more money to clean it up. So that's, I think, something to keep in mind. It's not at the front of anybody's mind when they're starting a business or coming up with a new mark often, but it's an important thing to think about.
Yeah, that's right. By the way, we talked a lot about the life sciences front, but also the chemical front. Technology and inventions are just as important. And I think that the drug industry has its own special issues regarding patents and intellectual property. But on the chemical side, they're huge. There's a huge number of innovations around, batteries, electronic vehicles, nanomaterials, and so forth. And I'm sure all of you do work for companies that are industrial or chemicals. Any special things related to these industrial innovations that are worth commenting, or some cases that are kind of worth following?
Well, I think in the area of plastics and polymers, it's been a fertile area for litigation over many decades, and the technology of plastic materials has pretty much been I wouldn't say perfected, but I think developed to a high level of sophistication. So I don't know how much you could actually say is being done by way of patenting inventions in those areas compared to pharmaceuticals or life sciences. But certainly those executives who are in the traditional chemical industries, batteries would be one application of hot engineering, plastics, et cetera, should also be aware of all these issues that we've been talking about up till now.
Yeah, that's right. Well, we do a lot of work with companies that are in green chemistry, and there's a lot of patenting going on there in terms of making chemicals out of something other than oil, such as biomass or corn or so forth. So, and actually it's somewhat of an intersection between life sciences, right, and biotech and industrial. Paul or Andrei, any comments on the industrial chemical side? Any special considerations or developments?
Paul, do you want to go first?
I mean, nothing that's really particular to the industry comes to mind beyond sort of general trademark principles that we've been talking about.
Yeah, that's right.
What I would say, Peter, is that executives, IP practitioners, et cetera, in the chemical industrial type companies need to pay very, very close attention to developments in the life sciences world. Because as Charles mentioned, all of this stuff is applicable, it's going to be translatable to their industries. And effectively what you have right now for the entire IP system, but especially for the chemical composition type industries, you have the life sciences, a public debate being the tail that's wagging the whole dog. And you have issues that we've already discussed. Whatever Congress or PTO, whoever makes decisions on Section 101, for example, for natural phenomena and products of nature, because that's what the life sciences industries dictate and political pressures, it's going to be applicable here in chemical compounds. Whatever they decide on, continuation practice is going to be applicable here. And here's a really important one on the international front. The decisions made at the WTO for waivers relating to COVID-19, people need to keep an eye on that, because I would not be surprised at all if arguments are being made that it should likewise be applicable for climate change technologies. A lot of people are arguing that climate-related issues are definitional for humanity, and technologies that improve the climate can be life-altering, and arguments can be made that the entire planet needs to have access to those technologies, so we have to potentially waive or amend international agreements in order to allow that type of an access. Again, this this dog is being wagged by the medicine's tail at this moment. That's the political pressure point, but it's going to have widespread implications in these related areas.
Yeah. And do you think, I'm quite familiar with the WTO because my wife actually was one of the Supreme Court judges of the WTO court. To what extent, and one of the criticisms, but also perhaps the reverse on the WTO is, can they enforce anything, right? And, so I guess the question is, you raised the fact that the WTO, passed some guidelines with regard to patents and so forth in life sciences and related to, the pandemic. Are those really enforceable or not, given the structure of the WTO?
Well, it depends what it is, but this waiver for sure is enforceable. So what the waiver, basically what it says is that certain countries can suspend their rules regarding patent protection for COVID-19 related vaccines. So now some countries that choose to go down that path could very well suspend their patent system. So if you have patents in that particular jurisdiction, if the country decides to go in this direction and suspend those rights, the next day you won't have patents in that particular jurisdiction. So it depends on what the WTO does, but for these broad-based multilateral agreements, they're definitely enforceable because they get ratified in each country, and then those countries can and will implement.
Yeah, that's right. Well, look, we've reached, we pride ourselves in starting on time and ending on time. There were no questions. I always feel that if there are no questions, it means that the speakers did an excellent job. Or at least when no one asks me a question when I give a speech, I just attribute that to the fact I did a great job. But I truly believe that's the case. I was very excited to get this panel together, covering different angles, whether it's trademarks or patents and so forth. And I do think that the three of you have done a great job of helping our audience understand what the issues are, what's changing, and what do they have to be concerned about as they run their companies. So I want to thank all three of you for an excellent job. Again, this is recorded and it's going to be available on the Societe website for those who want to watch it over and over again. And I want to thank all of you, and I want to thank the audience for joining us today and on what I think is a very important topic for the industry. So thank you very much all.
Thank you.
Thanks.
you.
Good to be with you.